So our first topic today is going to be on Prop 22, California Prop 22, and what it means for gig workers and how that may affect people across the United States outside of California if this becomes a trend. So for the basic background on it that you'll need to understand is that in September of 2019, California passed Assembly Bill 5. This is known as colloquially as the gig worker bill. And basically what it did was it extended the employee classification to gig workers. So this is like, rideshare, like Uber, Lyft, Postmates, Instacart, Grubhub, these types of companies. And what it essentially was trying to do was get rid of what a lot of legislators view as a loophole that these gig companies are using by calling their employees independent contractors in order to not have the same requirements as far as benefits, healthcare, and other things like of that nature. For Assembly Bill 5, once it passed, it created a three-pronged test for independent contractor claims. So a company would have to fulfill all three of these in order to be able to, legally claim that they had independent contractor as opposed to an employee. And those three things are that the worker is free to perform services without the control or direction of the company, which these companies are able to satisfy because, Uber drivers, Lyft drivers, they pick their own hours. They're able to choose when they want to work, and they are not told what to do directly by the company. Rule number 2 is one that ends up being a problem that they are trying to deal with, and that is that the worker is performing work tasks that are outside the usual course of the company's business activities. So what this means is that when you have a company like Uber where its primary business activity is, transportation of people, that means that if a worker is transporting people, then they are performing normal tasks, not tasks outside the usual course of business. This is the issue that these gig companies are having. And a good example of what would be considered an independent contractor under this Assembly Bill 5 would be, say you are a person who, say you own a business and you need to paint the outside of that business. If you hire a painter to come and paint the outside of that business, but you are, say, a bakery, then that painting would be outside your normal business activities, and you could consider that person an independent contractor according to Assembly Bill 5. And number 2 is the one that they have the issue with. And number 3, the third part of the test that you need to satisfy is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So this is, one that they're able to satisfy because it's independent of the rest of the company. This is not, a issue they're having. It's number 2 is the primary one. And so the conflict ends up being that the ride shares have, a difficulty with requirement 2, and they're actively fighting this measure of Assembly Bill 5 with Proposition 22. And that's going to be on the ballot in November. And on top of that, they've been threatening to, leave California if they end up not prevailing, because California has let them know that they are currently not, acting within the law according to Assembly Bill 5. So what this means for you if you're a voter in the state of California is you either vote yes or no on propositions generally, and a yes vote would support defining rideshare workers as independent contractors, and it would not subject the rideshare companies and employees to Assembly Bill 5. And essentially what this would do is it ends up limiting the benefits that those workers would get if they were considered employees. And then a no vote, which is your other option, would be to oppose this bill, and that would mean that California Assembly Bill 5, which requires the 3-prong test for proving independent contractor and not an employee, it would make that Assembly Bill 5 still valid for app-based drivers. And the logic behind this is that, they would give them the protections that an employee gets versus those that are lesser of an independent contractor. So let's look at the why. So categorizing workers as independent contractors means that they are exempt from a lot of different protections like minimum wage laws, overtime laws, unemployment insurance, health care subsidies, paid sick leave, vehicle accident insurance, mileage rates, all of these things that most other employees are able to benefit from and inside the state of California are required to benefit from. When we're looking at each of those, I mean, I think everyone is well aware of what minimum wage and overtime is. Unemployment insurance is, the unemployment benefits that the government pays out to unemployed workers. Those are paid by companies. And so if companies are getting out of that, then essentially they are not providing to the unemployment insurance within that state. So that's another reason that California is looking at this as a problem, is because they see these rideshare companies as skirting their public responsibility of paying into the system. And so, yeah, that's a pretty big deal. And then also one thing that people don't consider is, say, like me working in an engineering job. If I have to drive somewhere that's outside of the normal, business, like to and from work, if I have to go on a trip, then, I would get a mileage rate of however many cents per mile, depending on, your company and whatever contracts you're under. This is something that they don't get. And it's a really big expense. If you've ever looked into driving for one of these rideshare companies, is the wear and tear and depreciation on your car for how much you're driving it. Also, this would, allowing them to be called independent contractors, would end up removing, not having to worry about protections for shift lengths and breaks. Specifically, employees in the state of California can only have shift lengths of 12 hours within a 24-hour period. And then also employee consideration will requires access to disability insurance and accidental death insurance, both of which are pretty big, perks of having a W-2 and job. And so those are the pros for workers. This will also increase California revenue, which will help the state budget. Talking about if it does not pass, Assembly Bill 5 will help the budget because of the increased revenue from the rideshare companies paying, their share of taxes that they have not been for the past several years. The possible cons for workers of, not passing this is that companies like Uber and Lyft have threatened to leave and then, try, because they basically said that they can't comply with the standards that are going to be set, or that are set rather, under Assembly Bill 5, and that without Prop 22 passing, they will have to leave the state and then, come back at some point in the future, but come back with less jobs because of the added costs to, meet these standards. And also the companies suggest that they would have to be stricter with their hours and be less flexible for drivers, which many argue would, remove the incentive for driving for those companies in the first place. As many of those drivers, one of the main draws is the flexibility. Now, I think it's really important to remember to recognize when you look historically that, this pitting of workers' rights by companies against everyone else, like consumers and the government, these types of threats of going away or increasing prices is a very old argument that companies use to fight minimum wage and other labor protections. And I'll go over, minimum wage in the next segment. But, California also has the highest admission standards, and we still sell more cars than anywhere else in the United States. It's an old trick, and generally speaking, it hasn't carried much weight. So just something to keep in mind, but that is the rhetoric that these rideshare companies are putting out. And specifically, these rideshare companies are putting out this rhetoric, are Uber, Lyft, DoorDash, Instacart, Postmates. They are all putting this out. And that's an important thing to remember, because it's, there's a lot of lobbying going into this. And specifically, you have just those 5 companies they funded the initiative, and they've spent over $180 million in, trying to promote this. and that makes this the most expensive ballot measure in California ever. So they have a lot of reasons to, to fight for this. These companies do, and so I think that's really important to remember. Also, I personally, again, see this as kind of a bluff of them, threatening to move if this proposition does not pass. Because when you look, California is too valuable of a market share for this to be a credible threat, in my opinion. California is the biggest economy in the United States. We have almost double the size of our economy is almost double the size of number 2 and 3, which are Texas and New York, at about like 2.8 trillion, GDP, whereas those are about 1.7. So, I mean, we're not. I don't see that happening. And historically in the U.S., California has has always kind of led the way in health and safety standards. And so I think this is something that even if you don't live in the state of California, that you're going to probably have to get used to, at least this type of legislation probably coming up in your state assemblies, because it's coming. And California is probably going to be setting a precedent with this, assuming that it, does not pass, but we will see. I think it's fairly obvious from, what I've been saying, that my personal opinion on this is that I will be definitely voting no on Proposition 22. You'll definitely have to read through it, and I have those links in the description below to the bill itself, to Assembly 5 bill, and to a simple breakdown, because the verbiage can be kind of confusing. So that way you can read it for yourself. But in my personal opinion, I think that I'll be voting no. And the reason is because companies that can't succeed while following the same rules as everyone else just aren't good enough to compete, in my personal opinion. I think that it's very important that we, put workers first and protect their rights, and realize that capitalism only works when there are regulations in place to make it a competitive market. When you have companies like Uber and Lyft that are propped up by venture capital that are not profitable, and are undercutting, workers essentially, I think that that's a really bad thing for the economy. And I think that it's something we should, be very wary of when it comes to embracing these new, forward-thinking tech companies. And my opinion, again, is like similar to the state of California, is that I think they've been cheating through misclassification of workers for years. There's, these, I know from myself, I thought about looking into, Uber and Lyft as like a secondary side income. And when you look at the costs associated with the, gas, mileage, depreciation, and you add that together, it just makes no sense. Like, you're not making enough to cover that, plus the amount you're making when you cover those aspects isn't making you more than I would at just going and working at a fast food job that had decent benefits. So in my opinion, I think they definitely need to have, some reworking around this. So that's why I definitely don't want to, vote for this to pass. And also I have it in the description box, is a link pointing out how these companies have also been bailed out by the United States taxpayers. So I don't really feel sorry for them, in trying to fund this type of a bill. Either be able to compete playing by the same rules as everyone else, or don't. That's my opinion on that. So that's why I'll be voting no on Prop 22. If you enjoyed this clip, be sure to leave a like, subscribe, and check out the full live version of the Wealth for 99 podcast, where we talk finance, economics, and public policy from a working class perspective. We'll see you there.